doing this morning, Trey?
Yay. Great.
Today's topic is paragraph 7, though we left something undone last month regarding counting dates regarding time in the contract. So I'm going to do a quick 5-minute overview of that because I looked into this very deeply and I think I got it figured it out. And I just want to start there. So I'm going to start with the FAR bar contracts, which are the as-is and the standard. They both have the same time clause, and this is the one we looked at briefly last time. It's F, and essentially it says that in computing every time period, so anytime you're counting days, you use calendar days. Always. Anytime you're counting days, you use calendar days. However, as far as when certain periods can end or when dates can fall on a certain day, only the date for acceptance of the offer and the effective date can fall on weekends or holidays. So I'm going to do a real quick example here to highlight this. Let's say we're on, and I got my calendar here. I know not everybody can see it. But let's say we're on October 1st. I just picked October because that's a month I have blank on my calendar. That is a Thursday. We've sent our contract off to the seller to be signed and hopefully accepted. We set the acceptance date as October 4th, which is a Sunday. Is that okay? Yes, that is okay, because the acceptance date is one date that can be on any day of the year. They see it, they like it, they sign it on Saturday, one day before. Well within the acceptance deadline, no problem. Now, can I make my and they deliver it to me. Can I make my effective date a Saturday? Yes, I can, because that is the other date that is allowed to fall on any day of the year. Now, notice these two dates are fixed dates. We haven't really computed any time periods. We kind of write in the acceptance date and we figure the effective date on the date that the offer is accepted and delivered. So now let's start computing our dates. We know our effective date is Saturday the 3rd, and it's no problem that that's a weekend. Our first time period is we have our escrow due date, and let's say it's due in 3 days. Now this is the trick to calculating all time periods. We never count the 3rd. That's day 0. So then we go day 1, Sunday the 4th, day 2, Monday the 5th, day 3, Tuesday the 6th. Therefore, escrow is due by midnight on the 6th. So again, we start on the day after the effective date is day 1, and we simply count out. Same for the loan. Buyer has to make loan application in 5 days. We just add 2 more days to our escrow due date, 5 days out. So that's effective date's the 3rd. So first day is the 4th, 1, 2, 3, 4, 5. Puts us to loan application must be made by midnight on October 8th. We have a 15-day inspection deadline. If I have my effective date on the 3rd, so I start counting my first day on the 4th, 15 days is going to be Sunday the 18th. Now I right away say, well, can this time period end on a non-business day, a weekend or a holiday? No, it cannot. Not under the FAR bar contracts. It gets bumped ahead to 5 p.m. the next business day because it's not the acceptance date or the effective date. So my inspection deadline, I have till 5 p.m. to do all my inspections and back out at buyer's sole discretion. Last one, let's say closing date was 45, or let's do the loan approval deadline real quick since that was the topic of our last talk. So that's 30 days out. 30 days falls on Monday the 2nd. That's no problem. And again, I'm using calendar days. I'm counting. As I'm counting 30 days, I'm counting every day on the calendar, including weekends and holidays. So that falls on a Monday. So that's midnight on Monday, November 2nd. That is exactly 30 days from October 3rd, the effective date, not counting the 3rd, starting with the 4th. closing date's 45 days out. That falls on November Tuesday, the 17th. No problem there. Again, I used every day on the calendar to count. I don't fall on a weekend or a holiday, so I don't need to bump it forward to 5 p.m. the next business day. Closing must be on the 17th. That's how you count your days. Now, just to touch on a couple of the other contracts, we have the FAR contracts, the commercial and the vacant. Their time clause is the same regarding, no, their time clause is different. And this is the one that we talked about a little bit last time. You, in computing all time periods, you count every calendar day unless it's a time period of 5 days or less. Now, this has to do with computing, not whether it can fall on or not, but just when you're computing. So if I'm computing the escrow due date, I still have my effective date as Saturday the 3rd, but I'm computing a period that's only 3 days out. That means I am not going to count Sunday. I'm going to count Monday as my first day, the 5th, Tuesday the 6th as my second day, and 7th as my third day. So my escrow is going to be due on the 7th under the commercial or the vacant, because when I compute time periods less than 5 days, I don't count every day on the calendar. I only count Monday through Friday, as long as they're not holidays. On the CRISPR contract, only business days are used to count time periods. So any time period. So if I have the CRISPR contract and I set my closing date for 45 days out, then that's going to be way out, because I'm not counting any holiday or weekend. So practically it's going to be much farther into the future than if I set my closing date under one of the FAR bar contracts or even the FAR contract as 45 days out. Because when I'm counting out, I'm using every day on the calendar.
What do you mean by commercial or vacant? Or vacant? Can you kind of explain that a little bit? Because if we don't have the contracts in front of us.
Yeah, I guess and I'm not exactly sure. I know you got Simplicity. I know different software provides these contracts. I get all my contracts from Altastar, and the ones that I have access to, the form contracts, are the 2 FAR bar, the standard and the as is, and then the Florida Association of Realtors commercial contract and the Florida Association of Realtors vacant land contract.
Oh, vacant land. Sorry. When you were saying vacant or commercial, but I wasn't sure what you meant by vacant, but vacant land is what you're referring to.
Yeah, I was reading my notes and it was shorthand. My bad.
All right, no problem. That's fine.
Yeah, vacant land and commercial. And those are the contracts I see. I don't really see the CRISPR. I don't know if you guys ever see it or use it. Anybody ever see that one?
What is that referring to? I'm not familiar at all.
I think it stands for contract for, let me see. I know it used to be more common. Contract for residential sale and purchase. And it's another one that used to be around more. Kristen, you ever heard of this one?
Oh, I'm
Anyway.
Which is it? Repeat.
Hey, Kristen.
Hey.
The contract for residential sale and purchase.
Yes.
You ever heard of that one?
Yes.
You ever see that one?
Of course.
CRISPR? Okay. But not very often, right?
No, we
You still see it around?
CRISPR ones, so we use the FAR bar ones.
Send it to the right email.
Yep.
Yeah.
So
That's what I figured. I was just throwing it out there for comparison's sake. It only uses the business days to compute time periods.
Yeah, I don't really know who uses that one. Other areas do, but we don't. So.
Yep. Yep. Okay. Cool. Any other questions on time periods?
So on the FAR bar one, you were saying it uses calendar days, and we started the contract date on October 1st, for example, but let's say that it was later on in the week, right? So let's pick a day like it was October 6th. So the third day would fall on a weekend, so then you just bump it to the next business day.
Are
or
you
5
looking
days.
at October 6, 2020?
Well, I'm going by the same calendar that you're referring to. I'm just taking the effective date and moving it from like the weekend into the middle of the week so that the third or fifth day would fall on a weekend, or not third or fifth, but you know what
Okay,
I'm
yeah,
saying.
no, because I was just looking at it.
So I'm saying, so if the third, like for escrow, if the third day falls on because you use calendar days, but if it falls on a Saturday or Sunday or
Right,
holiday, you bump it to the next weekday or the next business
exactly,
day. Okay, and same thing with
exactly.
loan application.
Yep, exactly. It's funny because you kind of think about it as far as computation. Anytime I'm counting out a period, I use every day on the calendar to count. But then there's the question of when can it fall on? What deadline? What day can be the deadline? And for most of them, except for acceptance and effective date, which really aren't periods, those are just fixed dates, they cannot fall on a weekend or holiday. They get bumped forward.
Okay, thank you. That's inspection, escrow, all the other stuff.
You're welcome, Melinda. If you want to keep doing more examples at any time, you can call me after this. And we
No,
can
that's
do
good.
it.
I just wanted to be clear because that's what I think everybody, especially with inspection, had, that was always where it was questionable. So you've cleared up a lot. Thank
Yeah.
you.
Yeah, the main thing that I really had to look up to be sure was whether or not you count the effective date as day one. And that's where it seems like a lot of people will differ. But I asked around a lot of people. I did a lot of research. I looked at cases where the judges were determining the dates. The effective date is day 0. Day 1 is the next day.
Maury, but the
Yes.
effective date, if after 5 p.m. goes to the next business day, correct?
My understanding is no, it doesn't. Oh, if it's after 5, the effective date can be on a weekend or holiday, so it's not typically bumped forward. If
Really,
it's
the
after,
date it falls, it's the time. If it's received after 5 p.m., I believe it goes, the effective date, if once executed, is after 5 p.m., it goes to the next business day. The
okay,
effective date. Is that
I'm
not
actually
correct?
not sure. All I know is that it
Let's
is
just
the
say the
date
last
on which.
signature we get is 10 p.m. at night. The effective
Yeah,
date would not be that date. It would be the next day. Is that not what?
I'm writing that down because I'm going to look it up because I'm
Yeah,
actually
look
not
that up
sure,
to double
Susan.
check, because that's what I've been
Yeah.
taught. I'm gonna make sure that's true.
Yeah, and it kind of sounds reasonable because I know the contract says your effective date is the date that it's been signed and delivered. But if I'm a buyer, or if I'm a seller and I'm delivering you the contract at 11 at night, that's kind of late. So maybe delivery counts as the next day. I'm going to look that up.
Yeah, would you please? Thank you.
And on these types of questions, if you guys think it's a good idea, I can just post the answers on Facebook instead of waiting a month to get back to you. Okay, any other questions on that before we move on to assignability? I think this is a lot of fun, counting the contract dates and stuff. Once I figured it out, now every contract that comes in, I count out the dates and compare them to the transaction coordinator just to practice and get good at it, because every contract kind of comes in with its own little setup, depending on when the dates are. Okay, so we're flipping to pop quiz. Who can tell me what page of the FAR contract the as is clause 7 is on? It is on.
Susan, you're muted. And I just gave you a thumbs up, but my camera's off, so I guess we're even.
It is on page 2. Gets right to it. Here's a pop quiz for you. What page is the one we talked about last week on? Financing, paragraph 8. Also on page 2.
Keep
Okay.
doing
Assignability. First off, if you have three options here, it's a 1-sentence paragraph. You check one box. Buyer may assign and be released from any liability. Buyer may assign but not be released from liability under the contract, or buyer may not assign the contract. If you don't check any, the default is that a buyer may assign the contract. And that's just a general Florida law that all contractual rights can be assigned. So keep that in mind. If you don't check any, the default is assignability. So when do you want to check what box? I'm going to look at it sort of from the buyer side. Then I'm going to look at it from the seller side. And then we'll see if you have any questions and throw out some examples and see if we can sort of iron it out. So when I'm doing a contract for a buyer, and I'm also going to look at it sort of in the commercial context as well as the residential context. If I'm in the commercial context, assignability is very common. And there's two reasons that I see assignability. One is sort of a wholesaler. You know, as you guys know, there's wholesalers out there, people that just enter into contracts so they can assign their rights for an assignment fee. And I don't see that as common. The more common one is in the commercial realm. People will enter into a contract, but they haven't yet created the entity that they're going to acquire the property in. So it will be assignable because they're going to assign it to an entity that's going to be created. See that all the time. Assignability in the commercial, I'm always going to get it for a buyer. And if I'm on the seller side, I'm not really as concerned about the contract being assignable because it happens. It's standard.
Well,
Now
that would come up too. Wouldn't that come up too when you're selling condos to parents for their kids? A lot of times they'll want to start up a LLC or something and they haven't done it yet. You know, they have all these different configs. So that would be an assignability one, wouldn't it? Or
Absolutely.
although I've had that done and I've just made an amendment that said, or addendum that said, you know, the buyer is la 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 la.
Yep. Exactly.
Oh, okay.
And that's, as we get more away from the commercial and into the residential, it's also common to not have your entity ready, and it could be an LLC. It could also be a revocable trust for estate planning purposes. So if a buyer, I'll ask a buyer, you know, do you want this contract to be assignable? Do you have any reason that you're going to change the parties taking title, or are you going to create an entity, or are you going to have a revocable trust that you don't have yet that you want to put the property in? And this also, a lot of times I ask that question, they say, oh, I already have a revocable trust, or this is going to be a rental and I already have an LLC. Oh, well, let's put that party on the contract and just acquire the title in that name, because then you don't have to do a transfer down the road. So it opens up that too. But if they say, yes, I do intend to put it in a trust, but I'm still working with my estate planning attorney, or yes, I do intend to put it in an LLC, but my acceptance date is tomorrow and my LLC isn't created. Okay, we'll make it assignable so you can make that change. Now on the seller side, as I said, in commercial, don't really pay too much attention to it, because the only time in commercial you might pay attention to it is if it says buyer may assign and be released from liability. Anytime I see that box checked, you pause, because if this contract gets assigned to somebody else, the original party is out. Now as a seller, I'm only looking to one party to close, and I may not have trusted any party like I trusted the primary party. If the primary buyer, the first buyer, is not released from liability, I'm okay if they sign it because they're still on the hook. Now I have two people I can look to, and that's in the commercial realm. In the residential realm, it's a little bit different because, as we know, most of our buyers are also borrowers. They're getting mortgages, and we put in financing terms for them. So if I'm representing a seller and I see that the contract is assignable, let's say buyer may assign but not be released from liability. My question is, why is this box checked? If this is a residential purpose, what is this buyer's intent? And if it turns out that the buyer's intent is just to assign it to an uncreated LLC or an uncreated trust, then let's go ahead and put that language in additional terms, because I'm okay with that. It's still on you. You're not assigning it to some different person out there. What I don't want is you find out you're really a wholesaler. You're trying to give me a little deposit, and usually that's what they'll do, give you a $500 deposit, check the assignability box, and try to put me in with a different party. But I've been told this whole time that you have a good job, that you've already been pre-approved, that you're likely to close. Now you want to assign it to somebody I don't even know. No, I've got a problem with that. I don't want this contract to be assignable as a seller. And the same when I'm representing a buyer, I ask, do you have any reason, again, to assign this contract? What are your plans? And if they have reasonable plans, such as transferring it to an entity or a trust or something, no problem. If it turns out they are, I guess if I'm representing the buyer and they're trying to wholesale the property, assign the contract for an assignment fee, I really don't care. Although I would be careful to check the box may assign and thereby be released from liability, because that's kind of a red flag to people. But if you're just giving it to a seller who's maybe not represented by a realtor or a lawyer, they might not even notice, in which case you check the box and I get my buyer the best possible scenario. Any questions so far?
No.
So that's really the way I look at it, is what we're dealing out with out there. And I think we're probably mostly talking residential at this point, is typically it matters who the party is. We pay attention to who the buyer is when we're looking at an offer, when we're looking at a contract. It's important what those financing terms are, and we ask, what kind of jobs do these people have? Who are they? Where are they coming from? And the reason is we don't want to tie up the property, waste our time as agents and title for someone who's not going to be able to close. So if we allow a contract to be assignable, that can completely change the parties we're dealing with. And we don't really want that unless there is a good reason. And usually that reason is it's not going to be assigned to just any old person for an assignment fee. It's simply, I'm working with my estate planning attorney. He should have my revocable trust done in a month. So we're closing in 45 days. Closer to closing, I'm actually going to assign this contract to myself as trustee so I can take title in the trust. One more thing that I was going to mention is a lot of times we'll have, and this is sort of what somebody was asking me, we'll have, say the parties on the contract are Mrs. Jones as the seller to Mr. and Mrs. Robinson as the buyers, but then very close to closing date, Mr. and Mrs. Robinson say, hey, we actually want to put our son or daughter on the deed. Technically, that's not the way it should go. Technically, we put the parties on the contract on the deed. So while I can say that it's really not a big deal to help a buyer out when they ask to change who takes title, especially when it's just a child, everybody does that. But if it's a commercial deal or a big deal, you're really going to say, look, I'm going to put the parties on the title who are buyers on the contract. If you want to change that, you need to make the assignment. And if you have that right, then it's no problem. You can assign the contract from Mr. and Mrs. Robinson to Mr. and Mrs. Robinson and their child. Now we put them on the deed. That is the correct way to do things. But like I said, in the typical residential scenario, that request is made all the time, and we do it to help people out because it's really not a big deal. It's not going to prejudice our sellers in any real way.
Because that will be published.
Any questions out there?
Okay, so a big reason why I wanted you to go over assignability and all of this is because a lot of people are really confused sometimes about that middle assignability one, which is, can you read it for me because it's in front of you?
Yeah. Buyer may assign but not be released from liability.
Right, so we can check that off when, say, you want your kid to be on the deed, but they're not on the mortgage. So they still have to sign the contract, and you're not really transferring it over to them at closing because they're already on the contract. But a lot of people go ahead and check that off because you kind of are assigning it to your child, or even though you're still on the deed with them because you're on the mortgage oftentimes. So that is what I wanted you to clarify, is that needed for that if they're already on the contract and they're already signing the contract. Because here, I'll go back about 2 or 3 years ago, people weren't putting their kids on the contract. They were just putting it in paragraph 20 saying add them to the deed at closing. But apparently some kid, they like foreclosed or something happened. The kid was like, I never signed the contract. I didn't know I was on the deed. I shouldn't be held responsible for this. So we started making sure that when you add your child, that who's going to UF, the student that you're buying the kiddie condo or kiddie house for, we're actually putting them and having them sign the contract. So do we still need to check off that middle assignability?
If you put the kid on the contract up front, then you wouldn't. Like if you were,
I'm still seeing it a lot, so I don't know if our agents are doing it also, but just sort of wanted to clarify that. And
yeah, if I have buyers who tell me that they're going to be taking title in the parents and the kid, then we can put them all on the contract up front, and the contract doesn't need to be assignable because we've got it right. But go ahead, Kristen.
No, go ahead. Finish your thought. But
I was just going to say, but the assignability retains me that flexibility if I need to change it. So if I have parents that are maybe wondering, if they've sort of told me once they're going to put their kid on, then they called and said, no, we're not going to put, let me go ahead and check this box because these people are probably going to change their minds in a month.
Okay.
And anytime you're representing a buyer, hey, if you think you can check that box, check it. It's just extra flexibility on the buyer side, and especially if you're only dealing with. It's hard to communicate on Zoom, isn't it? I can't wait till we can. Go ahead, though.
But typically, if they're waiting last minute, they still, now the closing companies are requiring us as agents to create an addendum adding them to the contract so that they sign something.
Yep.
What you're saying, and this is what you're doing.
Yep. And that's, like I was saying, that is really the correct way to do it.
Yeah. And then also with the husband and wife, a lot of people, marital couples, want to just have one of them on the mortgage, and so that the other one's credit is freed up. But again, you're still writing both of them on the deed. And do you have to, because it's a marital asset anyway? I mean, homestead, it's a marital asset. With investment properties, if say the wife buys the house with and they're the only one on the mortgage, do they need to include their husband or wife if they care? I mean, I guess only if they care to be on the deed also, correct? Like onto that contract.
Yeah, so if you have a situation where you only have one person borrowing the money, but you want both people on the deed, you both need to be on the contract. And I think, that's the the original question that, yeah, they both need to be on the contract, or at least we need to put one on the contract and do that addendum saying to add this person to get around what you were just saying. Actually, I've never read that case. I remember I asked Ray this because he's obviously got a lot more experience, and he said it was common back in the day to just put one party on the contract. And he said, as a lawyer, anytime, you never want to put more names than you have to. He said, if he enters a contract, I'm only putting my name, because if this comes to litigation, you don't want to have extra names out there. So you don't put your spouse to. Years ago, apparently, it was common practice to only put one name on the contract, but you had in additional terms, you could just write in what you wanted title to be. So that way the spouse gets on the title, but is never on the contract. So if it comes to litigation, the opposing attorney can only list one defendant.
And that's why
that's good. But then you brought up that case, which makes sense to me, that somebody could complain that they're being put on title and they didn't sign anything. So then you solve that by creating the addendum that they signed, so they're recognizing it. But then I wonder,
changes that I've noticed, and I just want anyone who's been in it longer than 5 years or around 5 years to understand why, and to make logical sense when you're writing up contracts or when you're accepting contracts. So some of us have been in real estate in other areas, and it's a little different. And some of us have been around to see what we were doing before, and now we want to know what the newest terms are and the newest way of dealing with this and writing up contracts are. So that's why I wanted you to go over this. I think hit the nail on the head.
Yep, and that's good. And I've only been doing this really deeply for 2 years, so I'm learning from you, Kristen. There's a lot that you learn from experience that you just don't get reading books. You got to be out there. So, but yeah, in general, assignability is flexibility for the buyer. Beware if you're the seller. Never let a buyer assign without liability. I entered into this contract with you, and I want to be able to look to you. I'll let you assign, but probably only if you're going to be, transferred into a trust or an entity. Otherwise, I'm dealing with you. And here's one little trick that you could do.
Are you going over to Ravel later?
I'm on it right now. It's a Zoom call.
Oh, okay, because I may need your help trying to do one of these webinars.
Okay.
I can never get on.
We're wrapping it up. Ray thought I was coming over to see you guys. I said, I'm on it right now. Say you're a buyer and you really want out, and I've checked the box for you, so you have assignability. We're still within that 30-day loan approval period, and I just want out because I found a better deal, or the market's tanked and I know I can get this property much cheaper. Well, what I could do is assign this to somebody who won't qualify for loan approval. That's a little bit of a ploy, but that highlights why, as a seller, you want to beware. Because if I enter into a contract as a buyer, conventional loan, 3% interest rate, whatever, 15 days later, the market tanks, I want out. All right, let me assign this to Joe Blow. He can apply for the loan. He steps into my shoes, because the person that you assign it to essentially steps into your shoes. Same contract, same everything, different person. That person doesn't apply for loan approval. We reclaim our deposit and we walk away. That's why, as a seller, now that's a ploy that most people probably wouldn't think of, but that's sort of why, as a seller, you want to think, especially in the residential side, why is this box checked? What is this person's intent? I don't really want my buyers to have that flexibility. I want my buyer in this contract obligated to close under the terms that we've agreed to.
But at the same
I'll
time,
look a little bit up.
with an investor, sorry, again, the Zoom call, but when you're working with an investor and they talk about, they might bring another investor in with them, or maybe an investor group with them, it doesn't hurt to check off that middle one, which keeps them
Not at
local,
all.
but allows them to assign it to maybe their LLC or other buyers coming in and jumping on, the investment opportunity with them. Because I've had that plenty of times, and that was nice to have that.
Absolutely. Yep, absolutely. If it's anything like that, investment property, yes, that's the way it should be. There's nothing wrong. You want the terms of the contract, but you don't really care if it's an investment group or they're assigning it to.
So basically what my thoughts are as the broker agent is, with assignability, do not ever allow your buyers, if you're working on the seller side, to check off that first one, which removes, tell me the wording.
Remove liability. Yeah.
Removes the liability. As a buyer, if you can get away with that, there you go. You have your out. But
Yeah.
ever, if you're the listing agent, allow that. And for the most part, that middle, check, which allows for, assigning it, but keeping your liability, like staying liable. That sounds like the general, you should keep that one every time. You should just check that one off every time, just for that flexibility that Maury's talking about.
Yep. Yeah, the only time I'd be careful is if I'm dealing with essentially a seller selling their primary residence to a buyer who claims it's their primary residence, but they're offering me a low deposit and they want to assign the contract. That just makes me think this might be a wholesaler, someone who thought they found a deal, assign it for an assignment fee. And I don't really want my seller dealing with, Joe Blow or whoever's comes along next who may or may not be able to close. Yes, I still have the original buyer liable, but having them liable is really a second best scenario. I want to close. I don't want to have to sue these people.
So as a seller, be on the lookout at that assignability and make sure you're making the best decision as a seller's agent for your seller. And as a buyer, try to get away with the middle one.
Exactly. Good recap.
Yeah. Awesome. Any questions? Susan Hicks, are you raising your hand?
All right.
Wait,
No, I think you finished mine up. Mine was with an engaged couple that, sorry, this thing won't leave me alone today. It was an engaged couple, and only the male in the relationship was being financed, but he wanted to leave it open so that he could add his fiance to the contract once they, because they were getting married in between buying the house, but he didn't want to add her until she said, I do.
Okay. Yeah.
So,
Yeah, that's a perfectly acceptable reason and why you would want to have that flexibility for them.
cool. Any other questions? Anything else from you, Maury?
No, that's it. That's it for today. I'm going to post some recaps on Facebook, and if you guys ever have little things come up along the way, please feel free to call me. This is a really good way for me to learn a little bit more as well, because until you have a situation to really dig into and apply these things to, it's all theoretical. And while that's a good place to start, you don't learn it quite as deeply. So I'm happy to bring whatever knowledge and skills I have to help you guys out and learn in the process. So let me know.
All right. Sounds good.
Thank
Maury.
you.
Thanks, Maury.
Good seeing everybody.
Have a great day.
Kristen, are we staying on or are we done?
I think we're done.
All right.
Unless anybody else has anything to say. We're good. Thank you, everyone.
Shay, and she's like, I don't know Shay. And then finally I was like,
Hello,
wait,
this
I
is
think
Kristen.
Who was I talking to? She's like, oh, you know, my friend Shay. And I was like, you guys are all here. She had a friend. That was actually not what I said. So confusing. It's like, who did I meet? Who was that?
I almost feel like we were on the real trip yesterday. We go and they did it so much easier to like put a face and a name and then we were talking about, which is like they never got me. So
I can give you Megan the Brits number again. So you can get a
With the Korean lady? That Bill guys? Yeah.
but you know, he had a picture of him and friends.
Oh, yes.